Oh, we're live. So let me make sure we are going live everywhere. Okay. Telegram. Um, and live on Twitter. Okay, so the first thing I want to talk about today is USCIS. I'm Curtis Morrison, immigration attorney, Ready to Law. USCIS has reinstated a long dormant practice of conducting neighborhood checks to vet immigrants applying for U.S. citizenship. That means green card holders that submit an N-400 for naturalization, and then they wait for their interview and to be able to take the test. Well, now USCIS is going to go talk to your neighbors and maybe talk to your coworkers and your employers back 5 years and see what they think about your moral character. This is nuts, but it's what they're doing. Let me see if I can share my screen here. So it was an August 22nd, 5 days ago memo. Journalist Camilo Montiel Galvez with CBS has wrote the story. And it says USCIS confers, let me see, rights, privileges, responsibilities that are vital to the security and safety of the United States. Okay, so these personal investigations, also known as neighborhood investigations, cover the vicinity of an alien's place of residence and employment and include at least the 5-year period prior to the filing of the naturalization application. I'm kind of furious about this because no one's former employer, I mean, sometimes, but usually your former employer is not your biggest fan. You left them, right? So that's not going to be good for some people. It wouldn't be good for me. So the purpose is to corroborate an alien's eligibility for naturalization, which includes the scrutiny of an alien's residency, good moral character, attachment to the U.S. Constitution, and disposition to the good order and happiness of the United States. Does that say happiness? INA 316. That cannot be a thing. Is that in the INA? I don't think that's in the INA. Has anybody ever? I don't know. Let's go see together. Gotta figure out how to switch tabs. See if the word happiness is there. Oh, it's there. This is in the Code of Federal Regulations. For all the relevant time periods under this paragraph has been and continues to be a person of good moral character attached to the principles of the Constitution of the United States and favorably disposed toward the good order and happiness of the United States. So if you are somebody that is Debbie Downer and not an optimist, now you have a problem because our country is going to give you scrutiny on whether or not you become a citizen because of that. Pretty crazy, but that's where we are. What else is going on? Last week, we had a partial victory in one of our travel ban lawsuits. That lawsuit is called Dine versus Trump, and it was before Judge Suknanan. I had gone to DC and for oral arguments on the 15th, and the order come last Thursday. The order, basically, we were not successful in persuading the judge to enjoin or cancel the ban. Okay. She upheld the ban as lawful, but she agreed with us that the implementation of the ban was not lawful because the president does not have the authority to suspend the issuance of visas. The president only has the authority to suspend the entry of a class of aliens into the U.S. And that's under INA 212F, also known as 1182F. So what happens now? In that case, the government has to give final decisions to the plaintiffs that don't have them. And a lot of times that will probably mean visa issuance. So we expect some Thine versus Trump, who are subject to the travel ban, nevertheless, to be issued visas, because if they're not, Trump administration is in contempt of an order here. However, this victory does not mean much to the plaintiffs. They are unfortunately facing this situation where even though they'll be issued the visas, they cannot enter the U.S. on the visas because of the entry ban. So the only way this will benefit them is if Trump, when he reviews the ban, as he promised to do in the proclamation itself, a lot of people forget that he promised to do that, but maybe because nobody's very optimistic that he will change it. But when he reviews the ban, maybe he gives new exceptions, or he cancels it, or changes the countries. Here's what it says. Within 90 days of the date of the proclamation, that was June 4th, 2025, and every 180 days thereafter, the Secretary of State, in consultation with the Attorney General, the Secretary of Homeland Security, and the Director of National Intelligence, shall submit a report to the President through the Assistant to the President for Homeland Security. I fear that could be Stephen Miller, describing his assessment and recommending whether any suspensions and limitations imposed by Sections 2 and 3 of this proclamation should be continued, terminated, modified, or supplemented. So there is a chance Thine plaintiffs with issued visas will be able to enter the U.S. with those visas if President Trump revises this proclamation. So I don't know what the odds are on that. Maybe 1%, maybe 2%. I don't know. It's a crazy situation, but I am glad that the judge upheld the rule of law, and that when Congress says something, that's what it means. So that's good. So next question. What are we doing with our other travel ban lawsuits? Well, they're before different judges. So we're going to make the same arguments, maybe improve upon those arguments to the other judges and see if they find our arguments compelling, that the travel ban betrays non-delegation and is unconstitutional, or if they follow this judge's thinking. So it could go either way. Right now, I lose count. We have 2 cases before Judge Chutkan awaiting orders on our leave. We've asked permission to amend the complaints and actually given proposed amended complaints. If you're one of our clients, that's CM 178 and CM 328 are those cases. We also have individual lawsuits that we have. We've amended a complaint in the Central District of California before Judge Carter, asking him to find the travel ban unlawful. We have filed a lawsuit in Massachusetts on behalf of an EB2 NIW, asking the judge there, I forgot her last name, so I'm not going to say her name, to find the ban unlawful, and also to find the application of the EB2 NIW interest exception unlawful, because they're not honoring USCIS's interpretation of the words national interest. the State Department's position is they can have a different definition for the same two words that another agency can. And that doesn't work that way. It's the United States. It's not like a bunch of little parts of rogue government that don't play with each other. They all have to be on the same page. Okay. So that's what's going on with our travel ban litigation. We also have a lot of litigation on behalf of Ukrainian U4U families. They're trying to adjust status before their diversity visa 2025 selectee status disappears on September 30th. We are seeing a lot of success in that litigation. We have not got green cards for all of our plaintiffs, but we are pleased and optimistic about the progress that we've seen so far. Okay. And for that, we've got cases we dismissed the one in Connecticut. We've got one in DC that's a group case. We've got one in the Southern District of Florida, and we've got one in the Eastern District of Pennsylvania. Okay, so let me skip over here to questions. And if you have a question, please ask it. I love to answer questions because questions coming from you all are what is on other people's mind. If you're thinking a question, someone else listening is thinking it. So go ahead and ask away. Okay, so Juan and Alex are asking, hi, Curtis. At what point in the process do they run these investigations? Before fingerprints, before interviews? Okay, so that is a good question. Let's go back because I didn't cover that. Here's the policy memo. It's 2 pages to see if it covers it. USCIS will make a decision to conduct or waive neighborhood investigations on an individualized, discretionary basis after reviewing relevant evidence contained in the records before USCIS. So there's probably going to be some things that are flags. They may ask for information to help them determine if they want a neighborhood investigation, such as testimonial letters from neighbors, employers, coworkers, business associates who know the alien and can provide substantial information about the alien, including any of the requirements for naturalization. Okay, so the audience for my video is the wrong audience right now because it's a bunch of immigrant families and the immigrant diaspora. I need to be talking to U.S. citizens right now because they need to step up to the plate on behalf of their green card neighbors and be offering to provide this evidence, right? Okay, so anyway, USCIS will review and weigh the evidence submitted as well as the evidence before USCIS in a manner that is consistent with general adjudication practices. So to your question, before fingerprinting or after fingerprinting, I don't think that matters, but probably after fingerprinting, because usually when you file a naturalization application, they fingerprint you pretty quick. You get that biometrics appointment right away. So I think that this is going to happen after that because there's no way they're going to implement a new policy quickly. Also, I'm curious who's doing that. Is USCIS hiring a bunch of people to go around doing these interviews? That's really strange. That's a lot of work, and I don't know who's going to do that work. So there's a lot of questions here. I think when I ask that, who's going to do? Are they hiring people? New special people? Special people. Special detective people. Detective type people. Should hire people in my family because whenever I eat cookies and I try to pretend like I didn't eat them, everybody always finds out. So anyway, that's my joke for the day. Abdullah Ali says no interview yet. Okay, Abdullah Ali, I don't know context. I don't know if you're a plaintiff in a lawsuit, what your visa category is. If you are a DV 2025 selectee, that is frustrating because September 30th is the deadline, right? Oh. Okay, let's go to this other question here. Help me user. I remember help me user. Hi, Curtis. How long it takes to get an answer for the travel ban lawsuits? Okay, so we have to use legal language when we're talking about lawsuits. So the process of a lawsuit is the government has to file a responsive pleading, which is often called an answer 60 days after we file the complaint. But I don't think that's what you mean by answer. I think you mean the final outcome of the lawsuit on whether or not the ban is lawful or whether or not the implementation of the ban is lawful. Lawsuits challenging policies as unlawful often take 9 months, 12 months, sometimes over a year and sometimes longer. That's because you have multiple steps. You have to get through the motion to dismiss phase. You have to get through the discovery phase, and then you have to get through the summary judgment phase. So it's a long road to take out the travel ban, but we're on that road. Okay. Now you probably are wondering as follow up to that, you're like, well, wait a second, there was just a hearing on the 15th. How did you do that? Well, sometimes when you have imminent injury, you can file what's called a motion for preliminary injunction and cut in line at the court to where the judge hears your case in front of others that are in front of it. And that's because the injury is imminent and it's irreparable. And with DVs, that's what was happening, because September 30th is the end of the fiscal year and their journeys end on September 30th. That's not true with employment-based. That's not true with family-based. There's an argument that it's true for students because they lose their admissions. Sometimes they're not deferred, but I don't think it's not as strong as argument as you would hope before the courts. The courts I've been before with student cases might not recognize that harm the way we would hope they would. So at this time, we only have one case. It was one of our existing lawsuits that were challenging the ban on behalf of students, and that's the CM 328 Jahani case before Judge Hutkin. And that's only if she gives us permission to. I wonder how long we should postpone our embassy appointments. Well, if you're subject to the travel ban, you should postpone or just not go until the ban is gone, because there's no benefit to subjecting yourself to the scrutiny of a visa interview and the cost related to the application unless you have a chance of getting something, right? If you have a chance of getting the visa. So if you don't think you qualify for an exception, and most people don't, then I would not attend the visa interview. Now, at the same time, you need to remember INA Section 203G. INA Section 203G says that you have to make an application within a year of receiving that welcome letter, or contact the embassy every year after that. And to be safe, I think that's true even after you've had an application, because there's a glitch in the system that will change your visa application to expired, and it's just easier not to fight them. So no matter what your situation is, make sure you have contact with the State Department, if wherever your case is. If it's at NBC, once a year. If it's at this is after your case is current, right? If it's at the embassy, with the embassy, and now you have to use that crazy visa navigator, but make that contact and save proof that you made that contact, because you might need it later if they try to say your visa expired or something. Okay, so I talked about the travel ban. I talked about Ukrainian U4U adjustment of status. We continue to file mandamus lawsuits on a regular basis, wherever you are facing delays in the immigration process, whether it be against USCIS because you have a delay with your N-400 or your I-130 or your 485, or if it's against the State Department because you have a delay getting interviewed or you have a delay after your interview. So remember that that's what we do. Individual mandamus lawsuits. Love to talk to you about them. You can go to our website and set up a consult for free. I do them via Zoom, although often my hair looks like this or even worse. So sometimes people tell me to turn off the camera. I'm just kidding. No one's done that yet. I'm sure it's coming. And I'll do it. I might turn off the camera for you all just to accommodate you. Okay. I don't see any more questions, so I'm going to wrap up today. Everybody have a good week. Take care of yourself. One more thing. I saw my paralegal has noticed that there is an update in USCIS policy on CISPA age out calculation. I haven't studied that policy yet, but just know that it's out there. So if you're in the US and you're like CISPA eligible, the Child Protection Act, on whether or not you're eligible for an immigration benefit, even though you're over 21, you need to be looking out for that because that's going to impact a lot of people. Okay. I will see you next week and next month. I'll see you in September. Okay. Take care of yourself.